Welcome back to another episode of Employment Law After Hours. Tonight we're diving deep into the latest shifts of the Equal Employment Opportunity Commission and what their goals, where they're filing suits, and what type of enforcement action they're taking against employers. By the end of this video, it's my goal that you'll know which kind of cases the EEOC is prioritizing, which ones it's backing off from, and where your HR team should be watching out for trouble. Now let's get into it. To understand where we are now, we need to see what's changing. Recently, an article was published from White and Case that notes a key shift in the EEOC in the cases it's filed. As some of you may know, the Equal Employment Opportunity Commission is a federal sub-agency of the Department of Labor that's tasked with primarily enforcing the anti-discrimination laws that fall under federal jurisdiction. Many employers out there are aware of the EEOC from notices that they may have received from it saying that they're investigating one or more cases involving discrimination or harassment in their workplaces. As of right now, the EEOC primarily lacks a quorum to decide which cases or lawsuits it will bring against employers. This lack of quorum matters. It constrains the kind of big systemic cases the EEOC can authorize at its central level. So what's the result for employers? Well, now there's going to be more traditional, or as I like to call them, day-to-day enforcement actions brought against employers. We are expecting to see lots more cases dealing with ADA accommodation disputes, harassment claims, and retaliation. And here's another headline coming at you. The Trump administration, we believe, has directed the EEOC to deprioritize disparate impact claims, meaning the agency is withdrawing or closing those kind of cases, pushing them more into the hands of the private plaintiffs rather than the EEOC standing in the shoes of those individuals. That doesn't mean that those cases won't be filed by those private plaintiffs or their attorneys. It just means the EEOC may not be shifting their focus on those claims or bringing them on behalf of individual plaintiffs. In short, the EEOC is really narrowing its focus. It's walking away from sweeping structural claims in many instances, but the risk still hasn't gone away. It's just shifting more to individual battles in court between plaintiffs and employers rather than the EEOC versus employers. So where is the EEOC shifting its focus? Well, here are the major claim types that we're expecting to really get the spotlight under the current Trump administration. First will be accommodation disputes, primarily disability or pregnancy accommodation. These cases are front and center for this administration. The EEOC continues to push enforcement in cases involving refusals to accommodate medical conditions or pregnancy-related needs. As many of you listening know, the ADA is a complex statute, and the interactive process to determine whether a reasonable accommodation can be made is very fact-intensive and very legally driven through prior court precedent. They're not easy cases to determine. Next, we expect this Trump administration to shift focus into harassment and hostile work environment type claims. Even without a quorum, district offices of the EEOC are handling claims where employees allege persistent harassment, often after prior complaints were ignored by the employer. Next, we're expecting the Trump administration to shift claims into focus on retaliation as well. And here's where employers better tread carefully. Punishing someone after they complain of harassment or discrimination, even subtly, can invite trouble. The EEOC is not shying away from these type of retaliation claims. So for example, if you have an employee who in passing says they may be experiencing some awkward conversations or awkward physical touches from another employee, and the employer doesn't take steps to investigate or correct that action, and then that complaining employee, even if they're complaining subtly, is terminated 2 or 3 weeks later for something wholly irrelevant. Those are the type of cases that the EEOC may shift focus on as a type of retaliation case. Next, we expect the Trump administration to also focus on religious discrimination. There's an uptick, or at least a watchful eye, on religious discrimination claims, especially around accommodations like Sabbath observances, such as on Sundays, vaccine mandates, or telework requests for religious reasons. In fact, just this week alone, the Trump administration has released guidance encouraging the EEOC to also focus on Christian discrimination when it comes to religious accommodations. Next, we expect to also see a bit of a focus on what some may call reverse discrimination, stemming from the DEI backlash the Trump administration engaged in back in January and February, where it revoked either previously issued executive orders or issued new executive orders instructing particularly public but also private employers to do away with DEI programs. Although not yet prolific in enforcement actions, we all know that DEI programs are under scrutiny by this Trump administration and therefore the EEOC. We believe there are currently talks in the administration of claims that diversity initiatives could perpetuate discrimination, such as DEI-based programs. And importantly, many disparate impact cases, which tend to focus on policies that disproportionately affect a protected class, even without intent, are being closed. The EEOC is basically saying, in our opinion, that, hey, we're out of the business of broad statistical claims unless special approval is made by the EEOC, and we're focusing on individual claims only of direct discrimination or direct harassment. So what does this all mean for employers, and what should employers be doing with this information? Well, here's a checklist that we developed of what we believe employers should be doing given this information that we've discussed today. First, regarding accommodation requests, make sure you're documenting your accommodation process. If someone asks for an accommodation, whether it be medical, pregnancy, or religious, go through an interactive process. Don't skip its steps and keep records of that process. Show that you considered alternatives, communicated with the employee, and made reasonable decisions. One of the biggest areas of ADA noncompliance that we see is a failure to engage in the interactive process, and that's such an easy area for the EEOC to investigate and ding employers on for not engaging in that process. Make sure you document it. Second, keep your complaint mechanisms robust. Make sure your harassment and complaint reporting system is trustworthy, well known to your employees, and effective. When an employee complains, act promptly to investigate, or you really risk letting those matters fester and grow when they could have been handled more easily and efficiently upon first complaint. Third, train managers about retaliation risk. Even actions that look neutral can be construed as retaliation, such as, quote, I reassigned her to a different position because of poor performance. Well, that might actually be construed as retaliation, especially if she's recently complained of harassment or discrimination. Even actions that look neutral can be construed by an employee as retaliation. Imagine a situation where a manager or supervisor says they reassigned an employee because of poor performance, but a week or two prior to that reassignment, they had complained of discrimination or retaliation. Even though the employer may believe they were in their right to reassign because of poor performance, in reality, that timeline may start to imply that, hey, look, this reassignment may be as a result of retaliation because of that employee complaining of harassment or discrimination. Always be mindful, always be careful. Next, although we haven't seen broad executive orders or other statutes or regulations specifically outlawing DEI initiatives for employers, employers should really be re-examining their DEI initiatives for legal risk. With greater scrutiny, DEI programs might draw attention. If an employer's training or target initiatives heavily rely on demographic-based preferences, they may begin to get questioned by the EEOC as being potentially reverse discrimination or what they may see as an unlawful DEI initiative. We're not saying necessarily to eliminate DEI altogether, but really know your legal footing when it comes to DEI compliance and how those programs may be construed. Next, anticipate private litigation in disparate impact cases. Because the EEOC is pulling back on disparate impact enforcement, some plaintiffs will take those claims on their own, straight to federal court. You could really begin to see more private suits in that area of law. So we really need to begin to maintain defensible policies and assess risk up front when it comes to disparate impact situations. Next, stay alert on religious accommodation and telework rules. The Trump administration has already signaled that in the federal setting, at least for the public employment, the EEOC has signaled that telework may itself be a religious accommodation. And that's, of course, a developing area of law where we could begin to see the EEOC shift to requiring or otherwise expecting to see private employers also allow a leave of absence as a form of a religious accommodation. Let's play a little bit of what if for a moment. What if an employee who's pregnant asks to swap to a lighter duty position and an employer outright declines the request? that could potentially be an EEOC, issue that's just waiting to be investigated and enforced. What if a DEI training says, quote, we aim for certain demographic percentages? Could someone allege reverse discrimination? It's certainly a possibility and one that we would expect the CEOC to potentially investigate and bring an enforcement action. What if someone complains about harassment and an employer does nothing until they end up escalating the situation, to their own private litigation or to the EEOC? Litigation is likely awaiting that employer, especially given the failure to investigate and remedy any type of harassing situation. What if a worker says telework is necessary due to a religious belief and an employer outright automatically denies the request? Yeah, the EEOC may come in and say, hey, why did you all automatically deny that request instead of going through the interactive process? Remember, the interactive process also applies to religious accommodation requests. These are the kind of fact patterns that we're going to expect to see the EEOC to investigate and potentially bring enforcement action. So in sum, the EEOC's enforcement is narrower, but no less dangerous for employers. The EEOC may be stepping back from large disparate impact cases, but we expect it to lean hard into accommodation, retaliation, harassment, and religious claims. For employers, really, the message seems clear. Tighten your processes, document everything like crazy, revisit your DEI strategies, and don't assume immunity just because, quote, big cases from the EEOC are going to be less common. If you like this breakdown, don't forget to subscribe to this channel for other updates for employment law after hours. We'll see you again next time.